Contract law is the backbone of every real estate transaction. Throughout this chapter, you learned what makes a contract valid, how contracts are created, how they are classified, and how they terminate. These principles apply to every offer, listing agreement, purchase contract, lease, amendment, counteroffer, or option you will ever handle. First, contract validity. Contract law answers the question: what exactly are the parties agreeing to do? A contract is a legally enforceable agreement created through a meeting of the minds. A clear offer and an unqualified acceptance of that offer. The legal status of a contract can be valid. All essential elements exist. Competent parties. Mutual consent, consideration, lawful purpose, voluntary agreement. Void, missing an essential element, e.g., no consideration, illegal purpose. It was never a contract at all. Voidable, appears valid, but can be rescinded by a protected party. Fraud, misrepresentation, duress, minors, lack of capacity. Unenforceable, valid in theory, but not enforceable in court, e.g., oral contract that violates the statute of frauds. Real estate contracts must include additional elements: writing, signatures, legal description, and compliance with the statute of frauds. 2. Contract creation. A contract forms through offer and acceptance. An offer is a written proposal that includes the essential terms. Acceptance must mirror the offer exactly. Mirror image rule. Any change creates a counteroffer, which kills the original offer and reverses the roles. Delivery of acceptance creates the binding contract. Offers can terminate by revocation, withdrawal before acceptance, rejection, counteroffer, expiration, death, incapacity before acceptance. Real estate also incorporates the mailbox rule, acceptance effective when sent, options, which prevent revocation because option money is paid, assignment, which is allowed unless prohibited, Arizona Article 26, which allows licensees to prepare documents but not give legal advice. 3. Contract classifications. Contracts can be classified by type: written versus oral. Real estate almost always requires writing. Express versus implied. Express agreements are stated. Implied arise from conduct. Bilateral versus unilateral. Most real estate contracts are bilateral, mutual promises. Executed versus executory. Most real estate contracts are executory until closing. Arizona examples demonstrated how implied authority, delivery rules, and express contract terms control timelines, cancellation rights, and agency obligations. 4. Contract termination. Contracts may end through performance. The ideal termination: both parties perform fully. Impossibility or infeasibility. Unexpected events make performance impossible, e.g., failed financing contingency after death. Mutual agreement or novation. Both sides agree to cancel or replace the old contract with a new one. Statutory rescission rights. Certain land sales, especially subdivision lots, have mandated cooling off periods. Unilateral revocation. Attempting to cancel without legal basis often results in breach, abandonment, and lapse of time. Failure to act may cause abandonment. Expiration dates end offers are contracts automatically. Void or voidable contracts. Void ends automatically. Voidable can be rescinded by the injured party. Breach and remedies. When breach occurs, remedies include rescission, forfeiture, earnest money, damages, liquidated or actual. Specific performance. Common because real estate is unique. Cure period. Notices in Arizona are essential. No one is in breach until they fail to cure within the cure period. Study points to help you remember key elements of a valid contract. Competent parties. Offer and acceptance consideration. Legal purpose. Voluntary. Good faith intent. Statute of frauds requirements. Real estate contracts must be in writing, contain a legal description, be signed by the parties, mirror image rule. Acceptance must match offer exactly. Any change equals counteroffer. Counteroffer rule A counteroffer. Terminates the original offer. Creates a new offer. reverses the roles of offerer, offeree, void versus. Voidable void equals never existed. Voidable equals can be rescinded by a protected party. Executory versus executed executory equals still unperformed obligations. Executed equals fully performed. Arizona Specific Points Article 26 allows licensees to prepare documents but not charge a separate fee. Cure period notice is required before declaring breach. Tail clauses in listings may allow brokers to collect commission even after cancellation.